Whenever I'm asked to describe civil forfeitures, having handled hundreds of cases in this area, I can only say that they are legalized theft and extortion. In conjunction with this theft and extortion has come a tremendous erosion of our civil liberties and our constitutional rights. In fact, today, forfeiture considerations are part of every drug case, every money laundering case, or every white-collar offense. Although the purpose of enacting these civil forfeiture statutes was ostensibly to take the profit out of drug dealing and reduce the drug trade, it's clear that there's been no success in this area. But forfeitures have become a very popular way for law enforcement agencies and prosecutors to raise revenue. Basically, the ones who seize the property get to keep it. And approximately 75 to 90% of all seized property goes back to the seizing law enforcement agency to spend as they wish. In one case where we attempted to have forfeited property go to a juvenile rehabilitation program, the law enforcement agency balked, and the funds went instead to the sheriff department's program. Although large-scale drug traffickers are supposedly targeted, this is really in theory only. Most forfeiture cases do not involve such people. Many involve innocent owners of one type or another. Many involve small-time offenders, and the extra punishment of civil forfeiture, in addition to the criminal prosecution, is unduly harsh. And many families suffer because of the seizure and the confiscation of their property. The loss has been totally disproportionate to the crime in many cases. In most cases, no crime is even charged or prosecuted, and there are no convictions. As I will indicate, the United States Supreme Court has recognized these problems recently and has issued several decisions in the forfeiture arena with respect to problems of innocent ownership and proportionality. While most forfeitures were initially federal, the state of California and other states wanted to grab their share of the revenue as well. And state civil forfeiture statutes were also enacted similar to the federal ones. There is some case law that both state and federal authorities may not go after the same property, and the court first assuming jurisdiction over the property exercises that jurisdiction to the exclusion of the other. The California state forfeiture statutes that became effective in January of 1989 were based in great part on federal law, although there was a somewhat different burden of proof. But because of the overzealous activities of law enforcement agencies in the forfeiture arena and the problems and inequities to those whose properties were affected, the law has been repealed. And on January 1st, 1994, the state's previous civil forfeiture statute will again take effect. Under these older statutes, in order for forfeiture to occur, there must be a criminal conviction, and the state must prove the property forfeitable beyond a reasonable doubt. There are exemptions from forfeiture for the family car and for the family residence if one of the owners had no knowledge of any unlawful use. However, in my experience, most of the forfeiture cases regarding real property and property of greater value were taken by the state officers to federal court, and this will continue to happen to a greater degree once the old state forfeiture statute takes effect in January. But it hasn't only been the state forfeiture laws that have come under intense critical scrutiny leading to their repeal, but the federal forfeiture statutes as well. In fact, some fundamental changes appear on the horizon under a proposed Senate bill introduced by Senator Henry Hyde that is currently being considered by Congress. These changes would place the burden of proof on the government by clear and convincing evidence, where it is currently on the claimant. It would eliminate the requirement of having to file a bond with the seizing agency before even being able to contest the forfeiture. And it would provide counsel for those who cannot afford a lawyer and hold the government liable for damaged property. While forfeitures were initially directed and advertised to the public as against drug offenses, recent federal forfeiture statutes have enlarged the property that's subject to seizure and forfeiture to include almost all financial and white-collar type offenses, including embezzlement or misapplication of funds, fraudulent statements in a loan application, mail fraud, wire fraud, bank fraud. and so on. The scope of these new white-collar forfeitures is still unclear. In one of our cases, the government seized an entire parcel of real property worth over $500,000 because a small portion of the down payment came from some structured funds, that is, cashier's checks under $10,000, although the money came from perfectly legitimate business sources. The government claimed the entire property was subject to seizure because it was, quote, involved in, end quote, the transaction. The statute contains the involved in language, and so they seized the entire parcel. In federal forfeiture cases, there need not be a criminal conviction or even a criminal case, although there is often a parallel criminal case pending, during which time the forfeiture case is stayed and the property is placed on hold for as long as it takes. The initial seizure must only be based upon probable cause. That's the same type of probable cause that's needed to obtain a search warrant or an arrest warrant, which is not much. This is the only burden, probable cause, that federal authorities must ever meet. If the case proceeds to trial, it will generally be bifurcated, and the probable cause aspect will be determined by the judge. At this time, hearsay is admissible, out-of-court statements. And then the burden shifts to the claimant, as if the claimant were a plaintiff. And the claimant must prove his or her case or a defense by a preponderance of the evidence. Hearsay is fortunately not admissible at this stage of the proceedings. Forfeiture cases are generally based upon one of two types of theories, or both: that the property was used to facilitate a drug law or other type of violation of law, or that the property was the proceeds of a violation of law. Now, in addition to proving that the property was not used to facilitate illegal conduct, or that the property was not purchased with illegal funds, there are some other defenses that a claimant could put forth, such as that he or she was an innocent owner within the meaning of the statute, which means that the person had no knowledge, or that only a portion of the property might be related to an illegality and could be forfeited, or any other number of defenses that emerge in each case. Civil forfeiture cases are regular civil cases with respect to discovery procedures, and both sides submit interrogatories, requests for production of documents, requests for admissions, schedule depositions, and this is why forfeiture cases are so costly and time-consuming. Often the government will not wish to produce an informant for deposition and would therefore be more likely to settle the case. Summary judgment motions, as in any civil case, are sometimes appropriate, particularly with some new defenses recently provided by Supreme Court decisions with respect to whether civil forfeiture, in addition to criminal punishment, constitutes a violation of the Double Jeopardy Clause of the Fifth Amendment, or whether civil forfeitures, which are a form of punishment, might violate the prohibition against excessive fines under the Eighth Amendment. But in my experience, most forfeiture cases are settled along the way, because the possessions are held hostage while the matters proceed, and it's generally in the claimant's interest to pay some percentage to the government and agree not to sue in order to get the property back. This will avoid the high legal fees, storage, maintenance fees, and attorney fees involved in protracted litigation, and the possibility of losing the case before a jury. The government feels the same way. And as in any civil case, both sides tend to evaluate the hazards of litigation, and the claimant may simply buy the property back for an agreed-upon price. Let me just discuss some common issues or scenarios that emerge in a forfeiture case. The innocent owner defense is often raised, and the question becomes, what is the applicability of the relation-back doctrine? Until recently, what is known as the relation-back doctrine indicated that the government took title to the property at the moment the illegal conduct occurred. And once property was linked to a drug violation or some other illegal transaction, even if it was years earlier, it belonged to the government right then and there, and no one could ever take good title, and no one could ever be an innocent owner. This included someone who may have purchased real property for a great deal of money, someone who received the property as a gift, or a spouse with a community property interest. The government argued that the relation-back doctrine always trumped the innocent owner defense. Courts did not always buy this argument with respect to someone who had spent good money, but they did with respect to community property and other interests. The Third Circuit Court of Appeals, in a case called Buena Vista, held that a donee could take title and could present her innocent owner defense. The government's theory would totally have eliminated this defense, even though it was provided in the statute. And this important decision has far-reaching consequences for children, for executors of an estate, for innocent spouses, for innocent people with a security interest, for innocent purchasers of property. Had the Supreme Court ruled the other way, this would have created havoc with our entire economic system, for no one could ever be sure that the property they owned was untainted back to the dawn of time. Now, what is the innocent owner defense? Some forfeiture statutes contain an innocent owner defense that requires the claimant to prove lack of actual knowledge that there was some illegality involved with the property. Some forfeiture statutes do not contain an innocent owner defense, but one has been read into them. The statutes permitting seizure of currency if a person fails to declare it upon entering or leaving the country contains no innocent owner exception. And the statute permitting seizure of a car or a boat or an aircraft also contains, for facilitating a transaction, similarly lacks an innocent owner exception. In some states, if a spouse is lucky to live in those states and the spouse proves to be innocent, the government may not even forfeit the guilty spouse's portion if it's held in the form of tenancy by the entirety, which cannot be severed except upon death or divorce or agreement of the spouses. As for joint tenancy or community property states, partition may be ordered and the guilty person's half forfeited. The D.C. Circuit Court recently issued a very significant decision in the Sheldon case, indicating that an innocent lien holder, such as a bank, could sue the government under the Fifth Amendment's eminent domain clause for an unjustified taking without just compensation, and the government must compensate the lien holder for the loss of their security interest and the inability to foreclose while the forfeiture case is pending. Several months ago, the Supreme Court issued the case of United States versus Austin, actually Austin versus United States, and recognized that civil forfeitures are punishment, and because they constitute punishment, the Eighth Amendment's prohibition against excessive fines is applicable. The Supreme Court left it to the individual district courts to determine in each case whether such a fine would be excessive, and of course there's no simple answer, and it would have to be decided in each case. Justice Scalia suggested that to forfeit a house where one drug sale may have occurred would constitute an excessive fine. The primary use of the house was as a residence, not as an instrumentality. And the government had even argued that there need not be a substantial connection, and real property was being forfeited based only upon the fact that a telephone call could have been made from the property to discuss a drug transaction. In one of our cases, the residence seized was not used to grow, store, or manufacture drugs. No drugs were found on the premises. No conversations ever occurred at the location. There was no surveillance of the location. No drug transactions ever occurred with respect to the property. And the forfeiture was based on the fact that currency was found in the house 5 years later when they went to seize it. I think the outcome of that case would be affected by the Austin decision. Recently, the Austin decision was instrumental in assisting us in settling a case involving the growing of marijuana plants for personal use inside a home. Real property may only be forfeited based upon a violation of law punishable by more than 1 year. And in our case, a jury would have had to determine whether the underlying offense was possession of marijuana for personal use, a misdemeanor under federal law, or growing, which constitutes manufacture and is a felony. Rather than taking a chance, the case was settled because there were equities to consider on both sides, including the claimant's social history and their background. The Fourth Amendment does apply to forfeiture cases, and a motion to suppress evidence that's illegally seized can be filed in both state and federal forfeiture cases, similar to the manner in which they're filed in a criminal case. Now, while the illegal seizure of the property won't prevent the forfeiture from proceeding, no evidence obtained as a result of an illegal seizure may be introduced in a forfeiture case. The government may, of course, introduce other evidence that it might have that is untainted. In addition, the Fifth Amendment right to due process has been held applicable to the seizure of immobile real property in the James Daniel Good case. And in that case, the Ninth Circuit said that real property may not be seized without prior notice and an opportunity to be heard in court. The Supreme Court has granted certiorari and will consider this case this term, and hopefully it will affirm the Ninth Circuit as it did in the Buena Vista case. Such rulings may prevent another situation from happening like the one where Donald Scott was killed in Malibu by officers trying to raise revenue through the forfeiture of his land, who went out to seize it without the prior hearing. The Supreme Court has held that money needed to pay attorney's fees for counsel of one's choice in a criminal case may be forfeited. There is no constitutional right at this point to the assistance of counsel in a civil forfeiture action, no right to use the seized assets to pay for counsel in the underlying criminal case. However, an attorney may take property as a fee and assert that he or she is an innocent owner, and may also argue that a defendant has the right to an immediate adversarial hearing where the property has been seized for civil forfeiture and there is a pending criminal case and the funds are needed for counsel. The Department of Justice does have a policy with regard to forfeiture of attorney's fees, and this includes strict guidelines for approval by the criminal division of the Department of Justice, and attorney's fees may only be pursued where the transfer appears to be fraudulent or a sham. There are many other sundry and esoteric issues that arise in any forfeiture action, too numerous to discuss here. For instance, in one of our cases, the question arose whether the government had to pay interest to the claimant after keeping his property for 4 years from the date of seizure, after the government lost the case on appeal. The government has argued that paying interest is prohibited because the United States has not waived sovereign immunity in this regard, and this case is pending on appeal. Many issues arrive with respect to the timeliness of filing the claim, or the timeliness of the government's filing of the judicial forfeiture proceedings, or what to do if the claimant is a fugitive, how to obtain a stay of the civil forfeiture case if there's a criminal case, and Fifth Amendment self-incrimination problems. What about the question of a claimant's mental incompetency, minor children? There are sometimes problems of priority between several agencies claiming the same money, including the Internal Revenue Service. There are also questions whether minorities are singled out at airports and the nation's highways for stop in order to seize currency. Standing to even be a claimant in a forfeiture case has been raised in many of our cases. The government may claim the claimant was merely what's called a straw owner or a pretend owner for the real owner, or whether a bailee who's holding the property has standing even to receive a notice of seizure. There's also the question whether the United States has the jurisdiction to seize property elsewhere in the world. Law enforcement agencies like to say that they use the forfeiture laws to go after these large-scale criminal organizations and drug traffickers, and that the property is only cleaned up if it goes to law enforcement and not back to the family or the person. But this is simply not the case. Law enforcement is interested primarily in raising revenue. The agencies then buy a lot of new equipment, spending it on themselves, becoming like little warlords in the process. There's a tremendous incentive for local police departments to grab property without any downside whatsoever. If no one files a claim, then they get to keep the property. If someone files a claim, the U.S. Attorney's Office represents them for free. It's free to them, but not to the taxpayers. So what if they lose? And if they win, they get to keep the property. The potential for abuse is tremendous, and the controls over abuse are almost non-existent. Maybe now that forfeitures have been extended from the drug arena to property belonging to, quote, respectable people charged with white-collar crime, there may be a greater awareness of the abuses and an incentive to call a halt to this extortion and theft that is going on daily in the name of the war on drugs.